are watching Germantown Municipal Television, your source for everything Germantown.
Hello and welcome to Law Talk on Germantown Municipal Television. My name is Vince Perryman and I'm a local attorney with the law offices of J. Vincent Perryman. Each month, Law Talk focuses on a wide range of legal issues and topics. Today's show covers employment law with us. With us now is attorney Tim Perkins. Tim, thanks for being with us.
Thank you for having me.
I think what's always interesting when we think of employment law, a lot of people will try and call it labor law. And earlier today, you corrected me because I was doing the same thing.
Right.
So what's the difference between labor law and employment law?
Well, traditional labor law is dealing with union representation, elections of a union, and those kinds of workplace issues, where employment law is a much bigger umbrella. It includes issues that are more civil rights oriented, such as discrimination issues, sexual harassment issues, also wage and hour laws that falls under the employment law umbrella. So things like, does the employer pay overtime correctly? Are you classified correctly as either an employee or an independent contractor? And also things such as Family Medical Leave Act. You know, are you given the appropriate amount of leave if you need to take it for either your own medical issue or perhaps a family member?
So I guess if I'm going to break that down into terms that I would understand,
Sure.
It would be that labor would be where you're dealing more in a union setting to where you've got a representative that negotiates on everybody's behalf. But employment is more where it's going to be the employer and the employee directly
Somewhat.
dealing.
You still have employment law issues that could absolutely occur within the context of a labor market. So you have like the labor representation issues is typically, that's traditional labor would be, you know, are we going to have a campaign? Are we going to bring a union in? Those kinds of issues. But employment law issues, of course, they're more universal in that, you know, a lot of the businesses in the Mid-South specifically are not unionized. And so you don't see a lot of traditional labor in this region. But employment law issues is something that everybody, if you have a job, more than likely you've encountered an employment law issue of some type.
Yeah, and I guess the issue, I get a lot of calls where somebody's trying to they want to find somebody that does employment or whatnot, where they think they've got a workplace issue or something of that nature. Generally, it's a really long description of what all had occurred, but as I know, and I guess you do as well, Tennessee's an at-will employment state. So as I understand it, what that means is you can be terminated at any time without any cause just because.
Just because with a caveat.
Okay.
At will, in essence, is you can terminate an employee for any reason or no reason at all, so long as it's a lawful reason. So if I terminate someone because I don't like them, that's legitimate. If I terminate someone because they happen to be an Aries and I have something against people born in the month of April, that's actually legitimate because that's not something that would typically be, it's not something that comes under the ambit of the federal discrimination laws. However, if I terminate someone because they're a female or because they're a Christian or because they're Jewish or perhaps because they're black or any other race, that is absolutely prohibited by federal discrimination laws. You can't claim at will and use an unlawful reason.
Okay, and I guess that's some of the interesting part of all this is when people are trying to figure out, do I have a claim, do I not have a claim? And you know, at any time of a termination, people are very upset. Now, the next time I terminate somebody, I'm going to figure out what their sign is and put it in there on the separation agreement because I just want to see what the unemployment office will do with that. So
they're going to give them unemployment.
Yeah, typically, how do these issues come about? does it come about because of a termination, or does it come about because of something that's going on in the workplace?
It happens, easily happens in both circumstances. A lot of times you'll have I mean, from an employer standpoint, if you've got an issue with an employee, perhaps their job performance is at issue. A lot of times these aren't clear-cut things, okay? So there could be, perhaps there's a hostile work environment that the employer is not really paying too much attention to, but should be monitoring those situations. And so the employee gets disgruntled and perhaps quits. Well, you've got a situation that happened while the employee was working there. You know, if the court ultimately determines that the employee quit because of the discrimination and the work environment was so hostile and that a reasonable person would have quit under those circumstances, well, then their voluntary separation from employment then becomes actually a termination called a constructive discharge. So it could happen from an employee standpoint, either because you did quit, because you're considering quitting, or just because the situation in the workplace is intolerable. But there's, you know, it obviously includes both issues in the workplace, perhaps. I mean, for instance, you get into things like FMLA. Well, that's an issue that primarily, the Family Medical Leave Act primarily deals with current employees needing to take leave for various medical issues. But it can also take place in the context of termination. For instance, if somebody takes 8 weeks of FMLA leave, then the employee or the employer turns around and terminates them under suspicious circumstances, it could be considered retaliation for having taken FMLA leave. So there's a variety of ways that the issues appear.
Okay, so, and I guess in this, what would be better, to go through what some of the typical issues are, or what you should do if you encounter an issue?
Sure. So I think the most common issue that people encounter today would be either discrimination in the workplace or wage and hour issues. The discrimination is kind of a bit of a wide ambit, because you have issues, like I mentioned earlier, from race, religion, sex, all the kind of the things that are protected by federal anti-discrimination laws. But you also have things that, like the Americans with Disabilities Act, that cover people that need to be reasonably accommodated. They need some kind of assistance in order to perform their job, and the federal law actually provides for that. But so that's probably the most issues occur because of perhaps the discrimination laws or the anti-discrimination laws. The other side of that would be wage and hour issues, which those issues typically occur because somebody is not getting paid overtime correctly, or a lot of employers like to come up with very creative ways to pay employees. And you can be creative so long as what you're doing complies with federal labor law, and you just have to be very mindful of what that means. And if you have employees working more than 40 hours in a work week, you're going to owe them overtime unless they're exempt. The exemptions are pretty limited. They're you know, typically professionals, attorneys, CPAs. Those are exempt categories. But most hourly employees, your typical employees, are not.
Okay. Well, and that's perfect, because we're time to take a break. So when we return, we'll continue our discussion on employment law. Please stay with us.
Hello, I'm Germantown Mayor Mike Palazzolo. I want to let you know about something special you'll be seeing in your Germantown water bill this month. In cooperation with the Germantown Education Foundation, the City of Germantown is asking residents to fill the fountain of knowledge. Donations to the Germantown Education Foundation directly support academic programs in the Germantown Municipal School District. To donate, please fill out the form, return it with your water bill. You can make a one-time donation or monthly contribution. For more information, visit www.germantowneducationfoundation.org, and thank you for supporting Germantown.
I think someone at my friend's school has this thing called autism. My friend's brother's son has autism. My neighbor's son has autism. My son has autism.
Autism is getting closer to home. Today, 1 in 68 children is diagnosed with autism. That's about a 30% increase in 2 years. Learn more at autismspeaks.org/signs.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. I'm Vince Perryman, and you're watching Law Talk. Joining us on our show is attorney Tim Perkins, and we are discussing employment law. Tim, before the break, we kind of explained the difference between labor law and employment law, and then gave some examples of, employment law issues and how they would arise. So if somebody is working and they think that they've got an employment law issue, whether they're being discriminated against, not being paid properly, or just whatever, what would be their proper course of action?
Well, the first thing I think to do, I think it's always important to get the opinions of others. Talk to your family members, your friends, and kind of get an idea, because the thing about discrimination especially, it has to be not only subjectively discriminatory, it has to be objectively discriminatory. So if you feel like you're being taken advantage of, but the whole rest of the world kind of disagrees with you, you might not have a case. And that's not to say that's not worthy of pursuing, but it's something I think that people need to get a little perspective in. Soliciting the opinions of friends and family is a good place to start, just to make sure that you actually have something that the general public would consider, a reasonable person would consider to be discrimination as well.
Okay, well, and then so with any of those issues, I mean, what would be your next step? Do you need to go get an attorney? Do you talk to HR? Where do you go?
Yeah, there's one of two avenues. 90% of the discrimination claims that you're going to encounter have to go through the EEOC first, okay? If you, for instance, if you have a race discrimination case, your first step, you can't just go file a race discrimination case in court. Your first step has to be filing a complaint with the EEOC. The advantage of that, it's a federal agency. They're tasked with investigating those complaints. They will contact the employer on your behalf. It doesn't cost you anything. And so they do a pretty good job of making sure that both sides are able to tell their story. The employer is forced to file what's called a position statement, in which they outline their side of the story, and the employee gets a lot of information out of that. Then you know what the employer's point of view is. That process, you have to file those the EEOC complaints within 300 days of when the discrimination allegedly occurred. So it's not a full year, and it's something that you have to do that in order to preserve your right to file a discrimination claim. The other route would be to go contact an attorney. I've dealt with cases where it goes either way. I've had cases where I've shepherded the employee through the process. That's sometimes a little harder to do with an attorney involved, because once the EEOC hears the phrase, "Oh, I have an attorney," they kind of, well, I can't talk to you. I have to talk to your attorney. So it's sometimes helpful though for the attorney to be there to kind of guide the employee on filling out the charge of discrimination and those kinds of issues.
Okay, yeah, and I think this is probably an interesting place to talk about from the employer's perspective, because a few times I've had very small businesses that I represent say, hey, we got an EEOC complaint. I write up a quick letter to the EEOC and say, hey, they don't have enough employees to qualify under the Tennessee Human Rights Act or what's the federal
Title VII.
Title VII, there we go. I've got it in my form. So what, I guess in that perspective, what should people be aware of as far as what laws apply and what laws don't apply? Right.
That's a really, really interesting question from a couple of perspectives. As a small business, you grow yourself under the coverage of more and more federal laws and state laws, frankly. So for instance, you start out and you're a one-man shop, there's very few laws that actually apply. In Tennessee, once you hit your 5th employee, all of a sudden you fall under the workers' compensation laws. So growing is a good thing. You just have to be aware of the implications of growing. There's an exception for that, by the way. In Tennessee, if you're a construction company, you are fall under the workers' compensation law since 2011, since employee number one. So if you're a sole proprietor business operating in the construction field, unless you file a written exemption exempting yourself from that law, which only the owner can do that. You can't exempt your employees, but you're covered from employee number one up. Once you cross the 8th employee, the Tennessee Human Rights Act attaches. That's the act that's kind of their state version of Title VII. So it covers sex discrimination, age discrimination, well, it's not age discrimination, but the race, color, religion, those kinds of things. Once you cross the 15th employee, that's when Title VII kicks in. So that's when the federal discrimination law comes into play, as well as the age discrimination, the Americans with Disabilities Act. The 20th employee that you hire, the Age Discrimination and Employment Act attaches. And then you've got a little bit of a cushion between 20 and 50 before you get a little bigger before other laws start attaching. But once you hit the 50th employee, the Federal Family Medical Leave Act, the FMLA, attaches. So you have to start offering full-time employees 12 weeks of leave for medical issues, pregnancy-related issues, things like that. And also at 50th, that's when the new Affordable Care Act attaches as well. So if you've got 49 employees and you hire the 50th one, you've got a whole new set of laws that apply. And then the last really area where there's more law attaches would be the 100th employee, which you're getting to be a pretty sizable company by that point. But at the 100th employee, the WARN Act, which is the workers, this one's always tough for me. It's, let's see, Workers and Retraining Notification Act. And WARN is basically an act that says if you're going to do a mass layoff or a plant closing, and you're going to terminate more than 50 employees within a 30-day period, and there's exemptions, of course, that you have to give notice 60 days in advance of that layoff. And then, of course, at 100 employees, also the Tennessee Pregnancy Discrimination Act applies. So there's all these graduated levels where it's a good thing to grow as a business. You're offering more and more people opportunities to earn income, but you're also growing yourself under more and more federal law coverage and state law coverage.
Yeah, and I think one of the things that's interesting right now to me is on the Family Medical Leave Act, what all that entitles an individual to. And I've never quite been clear on that because I'm always surprised when somebody's like, oh, well, my wife's going in for surgery, so I'm taking a little bit of time off under FMLA. And I'm like, well, you can do that, and it's just one of those things that I'm ignorant on that, so can you enlighten me?
Right, well, I mean, there's lots of, companies have policies that cover a lot of this stuff too, and so a lot of people think that because they're entitled to leave, that means they're entitled to pay. And that's not always the case. I mean, well, it's just not the case. But generous employees very often say, look, if you need to take pregnancy-related leave, and that applies not only for the ladies, but for the men as well. Either side can take pregnancy-related leave as long as your employer is large enough to fall under the ambit of federal law. And those leaves are protected. They can't terminate you. They can't replace you. They have to preserve your job for you. So that when you come back, it's, you pick up right where you left off, and it's for 12 weeks.
Okay. Well, and right now we're at a break, but when we come back, we'll talk more with Tim Perkins about employment law. Please stay with us.
Pretty much a good day for me would be people leaving their hands off of me. I'm always called names. Everywhere that I go, there's always someone calling me names, calling me gay. I've been choked, thrown up against a wall, punched. Nobody's ever tried to help me.
Get caught buzzed driving, and you could do some hard time.
Craig, knock it off.
Sorry, Mom.
It could cost you around $10,000 in fines, legal fees, and increased insurance rates. And that could set you back a few years. Buzzed, busted, and broke. Because buzzed driving is drunk driving.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. With us now is Tim Perkins. We're talking about employment law. Tim, we were talking about Family Medical Leave Act before the break, and one of the things that I've always been curious about with this from both the employer and the employee side is, on all these different employment laws, can a contract change what you're entitled to? And the question is can the contract, can you agree to have less rights, or can you only agree to have more rights?
You can only agree to have more. As an employee, your employer cannot contract you down into fewer laws or fewer coverage, or less coverage, I guess I should say, than what the federal law provides. It's the floor. Federal law is going to set what the bare minimum is, and employers are always welcome to offer more than what the federal law provides, but you can never offer less. A lot of times employers get in trouble. For instance, you mentioned earlier about Tennessee being an at-will employment state. Well, if I give you an employment contract that with all the bells and whistles, and I tell you that you're employed for a one-year term, I've just destroyed at-will employment. So now your expectation is to be employed for a year. Then I have to have good cause for terminating you. Whereas if I hadn't give you a written contract for a specific term, you would just be an at-will employee, and if you weren't performing up to expectations, I could terminate you for any reason or no reason at all. So it is an interesting thing that you can get yourself into pickles by trying to do more than what's required.
Well, then it explains, the first attorney job I had in Memphis, they didn't want to put anything in writing whatsoever, because they just didn't, but now it makes sense.
They were prescient, Vince. Very. They
yeah.
They don't want to walk themselves into a breach of contract issue. Whereas in the absence of that, at-will employment would attach. So.
Okay. So now, as far as finding a qualified attorney to help you out in an employment case, what would be your recommendations on that?
First thing I would do is find out if you have any friends or family that are attorneys. That's not necessarily meaning that they're going to be the ones to represent you, but attorneys are a great resource in that if they're practicing in the community, they have friends that they either went to law school with, that they've practiced with, or that they've practiced against. And believe it or not, even the ones that you've practiced against are often a great resource. It's a very collegial profession, as you're well aware. So that's the first thing I would do. If you have a friend that you know that's an attorney, I'd ask them for a referral. Typically, most attorneys, to cover themselves, are going to give you 3 names, and you go. I'd advise you to call those 3 names and get some information from them and see if if it's a good fit. Internet's another great resource. Sites like avvo.com, lawyers.com, martindale.com, which is Martindale Hubble. Even Google these days, because Google's probably going to lead you to one of those 3 resources. But all of them have sort of a review mechanism in place where you can go on there and read, if the clients have done it, client reviews of what the attorney has done, or perhaps other attorneys' appraisal. Martindale.com, as you know, ranks attorneys and gives them a rating. And so there's an ability to go see what their peers think of them. So, those are all great resources if you don't have somebody that you can contact and kind of ask for a referral from.
Yeah, and I guess this is also the other interesting nuance with any area of laws. Like if you're going to somebody for medical malpractice or personal injury, they're generally not going to charge you something on the front end. It's all contingent based. So, but in my estate planning world and tax world, I'm charging you from day one. Right. Well, how does that work for employment cases?
It depends from an employee standpoint or employer, for one thing. Most employers are going to retain an attorney that they pay by the hour. Typically, there's going to be a retainer involved based on the type of work that you're seeking from them. If it's something like drafting an employment handbook, which is an absolute necessity. No matter the size of the business, as you grow, you need those kind of protections in place. And sexual harassment provisions are always something that you need in there. But it's one of those things where that it's kind of a case-by-case basis on what you're dealing with as to how the attorney is going to charge for the work. On the employee side, one of two things is going to happen. Most of the federal laws dealing with discrimination or employment law issues have attorney fee provisions involved. If the attorney is confident in the case and thinks it's a slam dunk, he's very likely to say, I know I'm going to get my attorney's fees out of this. I'll take your case. We're going to work on a contingency, waiting on what to see what the court's going to award. If the attorney is less confident in the case and thinks there may be some issues with it one way or the other, and he wants to test your resolve as a client, as an employee, are you serious about this? Then a lot of times those cases are going to require a retainer of some sort in order to engage the attorney services.
And if somebody's looking at, trying to figure out, okay, do I need an attorney, do I not need an attorney, and they want information on like the EEOC process or something like that, where would they go to get that information?
Right. Well, the first place I would probably go is just the internet, just to look around. I mean, it's a great place to learn things. It's not a great place to learn things that you then act on without consulting other resources, but it is a good start. I mean, there's a lot of things out there that kind of give you some information to get started. But call an attorney. Most of the attorneys in the employment law world aren't going to charge you for a consultation just to hear if you have a case. So if you legitimately think you have a case, you've checked with your friends and family and kind of bounce ideas off of them, they agree with you that you might have an issue, I think it's worth probably sitting down with an attorney for an hour or bending their ear on the phone for 15 minutes to talk those issues out.
Well, and I think the kick too with that is on your friends and family that you're consulting with on your issue. Make sure they're reasonable and rational family members, not the ones that are always the
not the crazy uncle.
Crazy uncle, or the little brother that likes to poke you with a sharp stick.
Right.
Things like that, because it's important that when we seek advice, we seek good, well-reasoned advice.
That's very, very true.
So and with this, as far as I guess the other thing that people should be aware of is they should, when they're going to meet with an attorney, they probably want to bring documents with them as far as any manuals from or the job offer or anything from the employer like that.
Absolutely. One of the things that, talking about contracts and things, one of the things that's very important is employment handbooks. They set policies. So federal law doesn't require that you have vacation, paid vacation, or anything like that. But if your employment handbook says that you're entitled to a paid vacation, well, guess what? That becomes part of your employment contract. So emails, communications, any kind of written notes of things that have occurred, and performance reviews, things like that are very, very important for the attorney to be able to give you a proper assessment of your case.
Okay, and our time is up for this edition of Law Talk. I'd like to thank our guest for taking time out of his busy schedule for being with us and sharing his thoughts and insights. If you'd like more information about Law Talk or any other program on Germantown Municipal Television, please refer to our website at www.gmtvonline.org. Thank you for joining us today, and be sure to join us next month for more discussion on legal topics. Until then, I'm Vince Perryman. Thank you for watching.